Well, hi there, folks, and welcome to this week's edition of Feeling Smarter. Joined in person today, Tim Miller. G'day, how are you?
Aaron, going pretty well. How are you doing?
Very well, thank you. Well, this week we held our Changing Face of SMSF, and one of the areas of interest was around disqualified persons. We saw a couple of cases that we spoke to, and it's an area that we have probably unfortunately seen the statistics within the SMSF sector grow as the ATO has looked to disqualify more and more people, either through action that they've taken or potentially through some of the other means which naturally fall within the definition of Section 120. So I might get you to sort of kick off about some of those important elements we need to think about when we might end up with a situation with a disqualified person, and then we'll sort of move into some of the specifics of those cases as well and what people need to be aware of, ultimately, most importantly, from this process.
Yeah, and look, I guess one of the comments that I made in the session was how, for a good period now, the ATO have taken more of an educational approach to breaches of, say, the investment restrictions within the SIS Act, and it's really been the worst of the worst that we've seen that have been disqualified over, let's say, the last 20 years, right? But what we're seeing now is not necessarily that the number of disqualifications has increased or decreased, because there's always a consistency of non-compliance, right? But what we're seeing is that there's probably a little bit more visualization around it, and because either trustees are not accepting of the decision to be disqualified, and so they're taking action to challenge that, or due to the nature of it, there's industry interest, and so we're digging deeper and finding out a bit more about these cases to get a better understanding about a couple of the key issues. And of course, the key issue being Section 120 of the SIS Act, which talks about a disqualified person, and importantly, 17A, which is our definition of a self-managed super fund, that says that you cannot be a trustee of a self-managed fund or a director of a corporate trustee if you are a disqualified person.
And to that extent, not being able to overlay someone to basically take on that role either. So you can't put in place an attorney to, in essence, step into your shoes. You are at that point done and dusted when it comes to the SMSF, both at a membership and a trustee level.
That's right. So excluding small APRA as your trustee option, there's very limited availability other than to, as in these cases, to apply to the regulator or to the courts for a waiver of your disqualified status to be able to continue to act. And so what we're seeing is more and more cases that have popped up of people trying to challenge their position for varying reasons, often to do with the administrative elements of acting as trustee of the fund, and so staking their claims as to them as individuals and their behaviours to put them up against the courts to say, well, do our behaviours warrant a second chance?
And previously we've spoken about the Merchant case, the Coronica case, but we have seen two cases recently at the polar opposite ends of the spectrum. So the Oral case is one where we saw a party go into bankruptcy. And ultimately what has transpired here is with the court is in essence found that they still are ultimately a fit and proper person. So the circumstances of their situation, builders, went through the challenges within sort of the COVID-19 period. And off the backdrop of that, as trustees of an SMSF, their lodgements are on time, they've done all the right things, there's never been any compliance issues and so forth. So if they were to, in essence, hit the nuclear button in respect to that fund, there's a raft of ramifications that kind of feel a bit unreasonable, other than the fact that the ATO are, the law is black and white in terms of what the commissioner can do there, but for the fact that there is an approach for the trustee to seek a waiver. And really, this is where this decision came about.
And so just to go over, I guess, the key issues of 120, where we talk about who a disqualified person is. And so in this case, in the Oral case, they're undischarged bankrupt, right? So once you are bankrupt and it's acknowledged that you're bankrupt, then you can't be trustee, and typically bankruptcy lasts for 3 years, and so you can't be the trustee, therefore a member of a self-managed super fund for that 3-year period. Of course, there's other circumstances where you would be disqualified, and that is largely from an SMSF point of view, anyone that's been convicted of dishonest conduct, which is one of those quirky definitions of, well, that's not actually a crime, dishonest conduct, but what crimes fit into that definition? And generally we're talking about financial based behaviours and activities. And then of course the next real key to disqualification is where your actions as trustee have resulted in the commissioner making a decision to disqualify you based on what you've done. And one of the key things that when the courts have been looking at these various cases, and Oriel was a classic one of that, what they're identifying is that the disqualification area is not so much about punishment. But it is. It's more about protection. So it's about protecting the interests not only of the fund, but also of other parties related to the fund and the public in general by your disqualification. And in the Oriel situation, we're talking about a trustee, him and his wife, and it was the husband that was disqualified because of bankruptcy. He had a building company, and that building company did suffer, as you say, through the COVID period, and resulted in debts mounting up and him not having the ability to pay those debts, so being declared bankrupt. Never was there any issue associated with the fund. Then the courts looked at it and said, okay, what's the protection element here? Who are we trying to protect from a public point of view? There's one unrelated entity that the super fund leases property to, that they had just gone through a renewal of their lease, and it was subject to a further 3-year renewal. So during the period of bankruptcy, there was really only one time of dealing between the trustee and the unrelated party. And so they felt that because of the behaviours of the fund, there was no real need to maintain the disqualification and allow him to, rather than have to blow up the whole fund, using your words there, they said you can continue on as trustee.
Yeah, so let's compare that then to the other case of Ombii, I think is the word that we'll probably describe there. And this was, again, a decision where it was taken to the review tribunal, Australian Review, ART, to, in essence, again, try and have that waiver, because in this instance, I believe it was the commissioner that decided to go through the disqualification, and off the back of the behaviours of that person, it was deemed that that individual was not ultimately fit and proper, and therefore, all those elements that you just spoke to were relevant here in making that decision to disqualify them under Section 120.
Yeah, and so this was an interesting scenario again, and you look at it, and you and I would look at this case and go, well, there's, why would you appeal it? Because we're talking about somebody who, on 117 occasions, withdrew money from their superannuation fund to pay their mortgage down
prior to a condition of release.
So not over 65, nothing else. They access super. In total, $120,000 worth of super over 6 years, right? And so there is clearly a pattern of events, and their argument with the courts was that they'd learned their lesson, right, and that they had gone out and received the appropriate education on this. They'd sought professional advice on this, and would not consider doing it again. And that the disqualification would harm their business where they were an accountant. And I think often it's all of those facts that come into it. Well, the courts have gone, well, then that's a risk to the public. If this is your behaviour in your own fund, what behavioural issues might you have with dealing with other people? But there is nothing to say that, okay, yes, you have been educated, but there's nothing to say that if your circumstances were dire again, would you go down the same path? And so the disqualification status was retained, and that followed very much along the lines of Coronica, which was quoted within the Ombii case, to say, well, there was multiple events that led to the disqualification over a long period of time, and your standing as an accountant was such that you should know better, and to I guess to take that to the final stage was the other one where we have seen the disqualification status waived ultimately is the merchant case, where we're talking a lot of money. We're talking like $50 million worth of tax losses or something there. But and so the ATO disqualified under the sole purpose test. But in that regard, they said we're talking about a singular transaction where professional advice was provided that the trustee acted on. And so they felt that by appointing a second director to the corporate trustee and retaining the member as the other one, that he didn't pose a risk to the public or to the fund. And so they waived the disqualified status there. So, it really does come down to what's involved in the transaction, how often are you doing the wrong thing, how significant are your breaches, and lots of factors that come into it.
Yeah, and I think that's the real important thing here as trained practitioners ourselves, it's being able to, so if we do see situations of non-compliance and so forth, well, we are starting to head down an avenue where the ATO may look at these things. There are, as you said before, some fairly black and white things that people will be disqualified by virtual bankruptcy and or convictions and that we spoke about. But it's where the ATO as regulator decides to take a much more active interest in it. So, and that I think is very much driven by the behaviours of the trustees. So their behaviours to remedy things before the ATO look at it, how they respond to it, all those sort of things. So I guess as we conclude today, what are your thoughts around that? And I guess what conversations should be having with clients that might be in those positions, and really so that they understand the fact that in some situations, well, this is the stick that the ATO could carry.
Yeah, look, I think my position is a long-held one. I've always, particularly in the 117 withdrawals, right? Loans to members of financial assistance has been number one with a bullet from day one of the breaches in the SMSF space. And I'm not sure how clearer we can be from an education point of view as to the amount that you can borrow from your super fund. Right? And so I think there really is that piece that when we're talking to clients up front who are looking to set up self-managed super funds, highlighting the importance of, if you do the wrong thing, these are the likely ramifications, right? So I think hit them hard with the fact that withdrawals will be treated as early release, taxed. Then there's potential penalties associated with that. Then there's disqualification. That disqualification is going to disqualify you from being a director, from being all these other things, and it's going to have such an impact on many other elements of your life. And so trying to get more people on board with hitting hard like the issues associated with doing the wrong thing in a self-managed fund.
And I think just to probably finish off on that, the other bit would be don't hide it. Front up. Early disclosure, voluntary disclosure, that sort of stuff then becomes really important in that, because the more that you try and drag this thing on or sweep it under the carpet, the more likely that the ATO will start to ramp up the opportunities that they have to remove the bad eggs from the industry.
Absolutely.
All right. Well, thank you. We've probably talked a lot longer than we would have normally, but I think it is a real interesting area. And again, something that we're continuing to see in this space was just a really good reminder as we take opportunity to take stock of what happens within our industry on these changing face of SMSFs. And if you are not a member, I think, Tim, it's a great example of as to why you should contemplate membership as we sort of drill into these on an ongoing basis.
Absolutely.
Excellent. Well, thank you once again for joining us for this week's edition of Feeling Smarter. Take care and have a great rest of the week. Bye for now.
See you all.